Act and then the NERA Act. However, this was largely about government, state researchers. Where was the regulation of private researchers? Okay, so these have been less regulated, and we have a number of regulations that come in from the NDA, from the UNCST, and from the Ugandan National Health Research Organization. Some of them are binding, some of them are not very binding. The UNCST regulations, I've always told people from the UNCST that you may not have this very binding when it comes to law. However, the NDA's regulations are actually legally binding because they are made under statutory instrument. The ones from UNCST are not. And then the National Health Research Organization has its own policy documents that have also been put in place, a number of guidelines. If they are not statutory instruments, they are not necessarily legally binding. They are as good as policy, they are as good as messages of goodwill. But in terms of data protection, that has currently changed. So if you look at the DPPA, what does it introduce? Number one, it gives legal protection to the principles related to data privacy. The Helsinki Declaration now has legal protection in Ugandan law, even though it doesn't say that. Ugandan law now introduces the same concepts and gives it legal mandate and legal protection. So things like informed consent, nowadays is not just a matter of ethics, it's a matter of law. I think there's a case that discusses that. Issues of lawfulness, what are you collecting the data for? What are you using it for? Have you followed the law? Is a concern. The minimalist principle, where are you taking the data for what? How long are you going to use it? Collect only what you need, not everything else. Use limitation, the same thing. Data quality, how much are you collecting? Openness, individual participation, and security safeguards. How do you secure your data? These things of being under lock and key. All these are now legal obligations, not things that researchers can do or not do. You don't do them, you are at risk of legal penalties, which we shall speak about also very soon. It also provides for a number of rights of research participants, and they include the right to access personal information held about that person. If you have collected information from me, I have the right to access it from you. I also have the right to stop you from processing information which is erroneous and it's part of my personal data. And also I have the right to complain to NITA about inaccurate data. But also, as we will later see, there's also the right to sue. In law, we have what we call heads of damages. That before you go to court, you must know why you are going to court. What is your head of damages? You're not just walking to court asking, oh, this guy's violated my rights. No. What are your heads of damages? Now, we have heads of damages introduced by an act of parliament. All right? So the DPPA makes the right to privacy and the duty to ensure confidentiality of participants, research participants, binding. Binding in law means something that ties you up, and therefore you must do it because it's the law. It's not because you like or because you're a nice researcher. No, you must do it. That's the law. I like this, criminal offenses. I see potential criminals in this room and also out there on Zoom. People have already committed. This law came into force in 2019, meaning many of you here have already committed these offenses. And the law establishes.
Keep close to the mic.
Okay, thank you. The law creates 3 offenses. The first one is unlawful obtaining or disclosing of personal data. Unlawful obtaining, so issues of informed consent. You know, how do you obtain data unlawfully? If you get data without informed consent, without me giving it to you, that's a criminal offense. If you destroy, delete, conceal, or alter my personal data, that's also a criminal offense. Again, if you do it outside of the law. And then thirdly, if you sell or offer for sale personal data of any person, you've committed an offense. And not just any offense, ladies and gentlemen, it's an offense carrying 10 years imprisonment as the punishment. How do you like that? Researchers in jail because of data violations for 10 years. Or the law usually has options, and I love the law for that. You can pay a fine of 4 million and 800,000 shillings. That may be easy, right? But also the law says or both. So depending on the judge and your transgression, the judge may decide that you pay the millions, or you go to jail for 10 years, or you pay the money and also go to jail for 10 years. And that's just the beginning of trouble. That's just the criminal offense. If the person committing this offense is an institution, you are hiding behind institutions, then every officer of the institution who participated in this crime commits a personal crime. And the institution also commits a personal crime. But because we cannot imprison the institution, they make it pay up to 2% of its annual turnover as a fine to the state. So you cannot hide behind an institution. They'll still get you from the institution, and even the institution has to pay. This is the law in Uganda. I'm not creating this up. And the law is not a toothless barking dog. It is very toothed. And I think maybe it doesn't bark that much. It has about 5 mechanisms of enforcement. Number 1 is the establishment of a designated unit within NITA. Okay? NITA, that's the National Information Technology Authority, has a unit, an office that reports directly to the directors, board of directors. It's called the Data Protection Unit. It reports to the board of directors of NITA, and its job is to force, it's the dog, it's the watchdog. Who is abusing data, who is doing this and this, it receives complaints, it investigates, has powers to investigate whatever has gone wrong. That's the office, and here it has been established, actually, it actually has people operating it and running it, so they're coming. Number 2, every institution must have a data protection officer. Every head of the institution is mandated to put in place data protection officers. Okay? Yeah, my thing has vanished. Okay, let me share again, I guess. Dr. Mwaka? Okay. Don't worry, I think I've learned a little bit about sharing. It's already shared. Good. Number 2, that's section 6. You must, and that's a duty I hope many of you have done that. Do you have data protection officers at your institutions? If you haven't, you're committing a criminal offense. Okay. Number 3 is establishes complaint mechanisms. Complaint mechanisms by participants to NITA. So they can complain about you and how you're misusing their data, and then the institution is supposed to violate, rather to investigate. And then you're like, okay, if they investigate, so what? That's where we come in. There's the action of criminal liability, which I've talked about. That's when they investigate you for misuse of data. Then you can be taken for criminal liability. The 10 years I talked about, remember? Now, there's something called civil action, and the lawyers love this. This is where we make the money. Civil action. These criminal things, there's no money. Civil action, there's money. Civil action, you sit down and formulate your own case, and then you bill costs. And I think people have already tested this a little bit, researchers. You bill costs. Whether you lose the case as the client or not, the lawyer still gets paid. So here we are making money as lawyers. Now, it creates what I told you, which are called heads of damages. There's a direct cause of action to sue researchers under section 33. If a researcher violates your data, abuses your informed consent, doesn't do this and this, and you can prove it, then you can sue that researcher, and there's no limit on how much you can sue. It depends on how you feel about it, how many millions you want or billions for that day. You talk to your lawyers will get the billions for you. Now, this is for other non-researchers there to know. So there's no protection in the law anymore. Even if UNCST came to court, it would also be added as another party. Hey, why not? We get more money. The more we add, the more money we get. Not so. And remember, I'm the small guy. I'm the research participant. You are the big guy. You are the researcher. And you NCST and all the others. You are big guys. We are small. So small guys are protected in courts. So this law is going to bite very soon. And we have to be very careful around it. Now, some things to watch out for. There are some limitations in the law itself. And I think UNCST and UNHRO and the others should take note of some of these limitations. Some of these standards are lower than those already imposed on researchers. So researchers maybe should be a little bit happy that some limitations here, some provisions here, provide for lower levels. That means the UNCST and the others must already start aligning their own standards to the standards in this act, because the Act of Parliament overrides what UNCST wants. That's something you have to think about. It has, for example, there's an issue around assent of children, and that's something that it doesn't provide for. In fact, it makes so many exceptions where children don't even have to say anything. And then it has so many clawback clauses. It gives you the rights and then takes them all away in the name of law enforcement. So if people who are investigating something to do with law enforcement, phony tappers, people want to steal your data from you as researchers, from government, if they came to you and they wanted that data, you are most likely to give it. So data protection, again, at the same time, the government is taking too much back by allowing state institutions to take too much from researchers. And then it also has the potential to undermine the efforts of the UNCST and other regulators in setting standards, because it has its own standards applicable to everyone. But for research, we had established our own standards, which is undermining. So watch out for that. But as you watch it out, I have some suggestions for you, what you can do as UNCST, as the NDA, and as the UNHRO. I have a feeling that we have to think about adapting this law to research. It's not a research law, like I said in the beginning. So how do we remove all this other wording and make it a crisp research law so that researchers understand it as applicable to researchers? For example, it talks about data subjects. We can talk about research participants. You can't change the law, but you can basically explain it. And I think UNCST and the other institutions can do that. Number two, let us popularize it among researchers. I've been on the rec for some years and I've never heard anyone talking about this law. So that means that we don't know it, perhaps. How are we going to popularize it among researchers so that they know if you do this, you are actually committing a criminal offense, not just a matter of ethical obligations? Number three, I think the UNCST, ND, and the others should take on the role of National Data Protection Office. If you read the act, it has a number of roles: investigating, looking at what people have done, overseeing research, overseeing data collection, basically. So if there was a negotiation, intergovernment, you talk to each other as government bodies that, what, guy, this thing of, research ethics, leave it to us. I have a feeling that we'll be better regulators than this office, which is going to be more political than anything else. So if you take on these roles, I think it will be very effective. And then number four, you may have to revise your standards and guidelines in light of the new act. You have the act overrides what you want. That means you have to look at it and then revise your standards accordingly. So basically, that is my last slide. But my conclusion is that all is not well. All is not well. The law has come into the area of research. You don't just wake up and do whatever you want to do just because you're a researcher, well-renowned. No, you have to do it in accordance with the law. It's a great piece of legislation as concerns data protection, and also a great tool in the arsenal of the UNCST and other regulators, although they are not even mentioned in there, but it's a tool that they can use very efficiently. However, researchers have to be very careful around it. More especially, be careful about the express power of research participants to sue researchers. It's an express power, and people will use it. Lawyers are picking it up, and they know, and people are going to go to court. We all know about the case of Mokoda and Naigaga versus this vaccine. Although no damages were given, I'm quite sure NVRI and the others are busy paying through the nose, at least the cost to the lawyers. And we all know what this means. So even though they didn't win, still someone, researcher will lose if you're dragged to courts of law. Number two, there's out of vigilance required as regards data protection, and there are lots of obligations which researchers must be aware of and must undertake. Lots of things, including which kind of lock and key you buy to lock your data somewhere. There are provisions to that effect. Therefore, this is a wake-up call. Let's wake up, researchers, regulators. Let's wake up. The law is here. You didn't oppose it when it was in Parliament. You now no longer have a chance. Just do what the law says. Thank you so much.
Okay, thanks very much. Thanks, Dr. Adrian Duco, for that very captivating talk. So I believe all of us have benefited from it. So please, if you have... Oh, sorry. Okay. Thanks. Hope everybody can hear me. Okay. Thanks, Dr. Duco, for that very captivating talk. I believe many of us. I don't want to call ourselves ignorant when we talk about the law, but of course we need to really dissect and understand it. So please, you can send your questions into the Q&A section of the chat. We'll read them after the next presentation. So I would like to introduce the next presenter. The next presenter is Dr. Helen Ryomerenda, the Director Product Safety at National Drug Authority. Dr. Ndajije has an accomplished regulatory career as the Director Product Safety and is currently the President of the African chapter of the International Society of Pharmacovigilance. Helen has been part of the organizing committee of the ANREC for the last 11 years, and she has also participated in quite a number of clinical trials that's ranging from Ebola, TB, HIV, neglected tropical diseases. She's seen it all. And Helen, you're very welcome to make your presentation.
Thank you. Thank you, Chair. And good afternoon, members. I'm really, it's a privilege for me to be at this UNREC and to it's a privilege for me to be at this UNREC and to be able to talk about compassionate use and emergency use of unproven and unregistered products during COVID-19 pandemic. There's a look at what has been. I need some help with moving the slides. What do you need? What do you need? Probably you should use this. Okay. It's not changing. Yeah? Okay, it has. Yeah, I would like to just take us a quick snapshot of what we've been through uh, about this compassionate use and emergency use of medicines, and also propose some solutions. But before I do that, of course, you have heard about a number of a number of occurrences in the past few, I would say in the past 2 years. A lot has been said about medicine, and it has gone in places that it has not been before, including in spaces very close to our homes, inside our homes, which has not really been the case. Medicine has been much talked about, mainly in the hospitals and the healthcare settings. So when I talk about drugs, of course, what is National Drug Authority is what I want to begin with. That we are an organization that has a vision to have safe and effective and good quality medicines in all of the country, and also our mission is really to promote and protect public health through the regulation of human and animal medicines. And one of the things that has also come out prominently during this period is use of herbal medicines. And why? Because of the COVID pandemic. This pandemic has really led to a lot of loss of life worldwide, not only in Uganda. And there have been so many innovations, and there's been increase in research, really looking for new therapies or model or novel therapies, and use of repurposed drugs, uh, even off-label use, I can say, looking for solutions to the pandemic. And that rush to use unproven products has presented numerous challenges to us as regulators, and the number of risks involved in using and taking medications has increased. So there's the need for very close attention to regulation of these devices during this period. And for Uganda, the regulatory framework really is the National Drug Policy and Authority Act, Chapter 206 of the Uganda laws. And specifically for research, the clause that we usually quote is the Section 40 that gives us a mandate over conduct of clinical trials. And there is also the clause that has been frequently quoted during these last 2 years is the Section 8 that talks about a drug not appearing on the national formulary, basically a drug coming in under emergency situations. And this is really the center of my talk today. But right from the regulatory point of view, if I look at molecules or new drugs coming on the market, they do not begin at the time you are doing the first trial in humans. Really, they begin at regulation from laboratory or testing out in laboratory animals. And then it comes to clinical testing. And the clinical testing, you go small scale, large scale, commercial scale. And for us, we also look at the evolving needs in terms of the indications or claims for which you make the product, or the routes of administrations, if they are changing. All these require clinical trials. And also when there are new disease indications. That's why I talked about repurposed drugs. You've heard of ivermectin. Professor talked about thalidomide, which initially was used for nausea in pregnancy, but of recent it came back as a product for cancer. So all these from the regulator side is really what we look at. So in terms of that section 8, what is compassionate use? Really, it is a program or a way in which the intention is really to provide potentially life-saving treatment to patients suffering from a disease, but for which no satisfactory authorized therapy is available, and they cannot enter a clinical trial. So for many patients, these are the programs that present their last hope. But of course, this is something that could also be prone to abuse, and this is the standing on which we came to base our decisions on emergency use listing. And in this, I just have a brief summary talking about what emergency use listing is. That usually, even before the emergency is declared as such, there are experts looking at available or possibly available products, or those that have gone at least the stage of animal testing. Some evidence is available, and then of course, everybody, all stakeholders come on board, including manufacturers, and they look at what could be, well, that is what was happening in COVID, what could, in pre-submission meetings, what could be submitted. And when those are submitted, some guidelines are of course, put in place to be able to assess that data and make decisions on how going forward, because there's limited safety information available. How is it necessary to put? Of course, it is necessary to submit more information, but how often and when, at certain time points, and also when the need arises, and when these data become available along the course, as soon as the submission is uh, is is accepted. As we get more updates, these are reviewed by various groups of experts. We have the groups that look at the product evaluation, that's the PEG, and there's also the technical advisory group from different fields, multidisciplinary, that helps with the decision after the emergency is declared, that helps the decision to continue reviewing and deliberating on the performance of this product. I'm looking at, for example, the COVID vaccines. And then information is made available publicly, and post-listing still information keeps coming through WHO to the countries that depend on this emergency use listing. For other stringent regulatory authorities like the US FDA, they already have this in their procedure. So it is the same procedure that come in their law. Sorry, it is the same procedure that is followed, but it ends up being an authorization because it is given by a regulatory agency, but it is really the same process that is followed. So in brief, what is emergency use authorization? It is really a mechanism to facilitate the availability and use of countermeasures, including vaccines during public health emergencies, such as the COVID pandemic. And it involves the use of unapproved products or unapproved uses of the approved products in an emergency. And one of the conditions is that there is no alternative, no available, approved, adequate alternative. And where we have used some of this in Uganda is at least for compassionate use. It's mainly been the Ebola vaccine. There were some ZMapp, monoclonal antibody. You've heard of remdesivir. It was initially approved for compassionate use, but it was later on also used in COVID. And favipiravir, sorry about that, also being used under compassionate use. So the main difference between compassionate use, sorry about that, I think it's a network. The main
Colleen, could you come and help, please?
Okay, so the main difference between compassionate use and emergency use is really one, that in emergency use listing or authorization, it doesn't require approval of the ethics committee because that approval is not, sometimes the product is not yet at that level. So that assessment, which is required by the ethics committee, is usually done by the group of experts that are already appointed even pre-submission of the application to the authorities. So an example of in the Ugandan setting, just to pick on the Ebola case in the outbreak, some of the challenges that's really looking backward, what happened, and some lessons we could learn was allocation of experimental therapeutics available in limited quantities, much as we accepted. And there was a certain area earmarked that was prone, and certain I say recipients or possible recipients, say, of the vaccine, the allocation to who gets it and who doesn't when they are limited quantities is a big challenge. And then there was also lack or use of in our situation, it was really lack of use of the adaptive clinical trial designs, which means that you get information on a rolling basis. You put the main pillars and accept minimal information of the safety, but you continue on a rolling basis. And that was even the clinical trial design is designed as such, and that was an issue for us. And then also the ethical considerations of the therapeutic access relative to the vulnerable populations, that pregnant women and lactate and children were often excluded from phase 1 and phase 2 safety trials of potential products, and yet they have to get or benefit from these promising treatments. So the other challenge is, of course, informed consent during such circumstances, and especially where the patients are really in a vulnerable state, and also consenting in a culturally appropriate manner, especially given the situation in which the Ebola virus vaccine was entered. The The other lessons that we have learned this from the COVID pandemic, really information sharing. There's been a number of platforms where you can quickly get information, but the only challenge is fake news, and you know, check your source. The complex trial designs, of course, that involved complex study designs were that were not available, or the opportunity was not there with the Ebola vaccine, have now come up. There are all kinds of types of trials that have come up across a variety of populations. Like platform also test trials that test several investigational medicinal product in one or multiple populations in a highly dynamic environment where done. So looking at some of those lessons and looking forward, one of the issues that has us, especially in the COVID period, has been reliance and recognition of recognition mechanisms, relying on other regulators who have looked at these products. And the difference between reliance and recognition is that reliance takes into account the work process of a trusted institution in reaching a decision, and we've relied on the WHO decisions during this time. And then the recognition is really an option to routinely accept work products of another regulatory authority or trusted institution. There we usually have to have a legal binding mechanism and or collaboration that is legal in between the institutions. So again, looking forward, really, it is to strengthen the legal framework to cater for even accepting that reliance, and then also the oversight and review of the regs has to also be strengthened in terms of representation in major health facilities, especially that now you have the vaccine and other products being more widely used. I said now there's more self-medication, there's more access to medicines. There's the rush, I talked about the rush to use maybe the herbal products and so on. So all this where a trial has first of all been submitted, or maybe also not submitted, talking about the earlier, what the other earlier presenters have been talking about, the opportunities can only be assessed to protect the patients or users of these products by having more presence in different parts of the country. And then also strengthening the technical capacity, of course, as the regulator to approve these trials for especially those new fancy designs, and improve local, the researchers, I mean, in terms of funding, in terms of equipment and all that is needed to do research. And then community engagement, sensitizing the community about how to handle these new products, what information, where to get the information, and also to help, and also to monitor, especially among the regulators, the interventions that are under study. I'd like to thank you very much for listening to me.
Okay. Thanks, Helen. Thanks very much for your presentation. And we have quite a number of questions. Is Professor Tumwine still online? The first two questions are for Professor Tumwine. Is Professor Tumwine still online? Okay. The first question. We have recently seen collaborative research which publishes in large groups of over 100 authors and sometimes under collaborative group names. What is your comment on this collaborative approach to authorship? Maybe let me ask the second one too, and you'll answer both of them. So the first one is on comment on collaborative approach to authorship, where there are more than 100 authors or so. The second question, an argument could be made that the authorship criteria such as the one recommended by the International Committee on Medical Journal Editors, disadvantages researchers in low and middle income countries in international collaborative research with researchers from high income countries. Such criteria also undervalue the contribution of local researchers in this context, who usually play an important role in participant engagement and data collection. How do we reconcile such criteria and the need for fairness in authorship? Professor Tumwine, over to you. Is Professor Tumwine still on? Oh, thank you. Have you heard the questions, Prof?
Some research needs as many as 100 people. Think about sending a rocket to Mars, for example, yeah? So you have many people involved in the conception or design of the work or the acquisition, analysis, or interpretation of the data. So if you apply the 4 criteria and 100 people qualify, yes, people will get joint authorship. And in as much as possible, when we do research, we try to be inclusive. We try not to exclude people. When we were medical students, we would see people from main campus at Makerere. Publishing, for them, it was single author book, single author paper. But we know that research, you cannot do it alone. So these criteria are trying to give credit to as many people that have contributed as possible. Let me give you an example. I worked at the Great Ormond Street Hospital for sick children in London. And I just finished my pediatric training in Makerere. And so we had a team meeting, and people were discussing the possibility of trying several medicines on asthma, in the treatment of asthma. And I was very active in that discussion. The medicine was called Slothrin. After that, I was doing duties like 4 nights. Hello, am I there?
Yes, we can hear you. We can hear you.
Hello,
yes, we are hearing you, Prof.
Oh, you are
we are hearing you, Prof.
Thank you. So I was on duty like four days a week, putting up Slothrin on these children, monitoring their asthma. And after that, I don't know how to say this. They short-circuited me. So I was fulfilling two of the criteria, but the other 2 I could not fulfill because they wrote their paper without involving me. And I moved to Zimbabwe And the first day I picked up the journal, and my name was not there. I was really angry because I thought I had participated. So these criteria are not meant to exclude people. They are meant to include them. However, just going to mobilize people to come for an immunization session, that is acknowledged. And the reason is that you are going to have authors who do not contribute adequately to warrant being authors. My second question, I think, was what was the second one? Authorship
No,
criteria or what? What was it?
The first question was on collaborative approach to...
Professor Mwaka, what was the second question?
I think you've answered both questions. The first question was on collaborative approach to authors. Then the second one was on the ICMJE criteria for authorship, where the one who asked the question was of the view that it kind of it's a bit harsh on authors from the low and middle income countries, especially in international collaborative research. You've answered both questions. Maybe one other question that has come in: how do we deal with the increasing number of salami publications and the available pressure for promotion?
So the salami publications are a big issue, and it's the departments and faculties who need to sensitize the researchers that salami publications are not much value because they don't have an impact actually. When you publish them, many situations, you don't get an impact. And impact is measured using how many times you've been quoted. So it is by sensitization. We should sensitize our people so that we don't write too many papers from the same research. But what happens is that you have a main paper which comes out, and then people can ask research questions on the available data, or they might have asked the research questions, but they are waiting to publish until the main paper comes. So, yeah, large studies can have many papers, but smaller studies shouldn't have so many papers.
Okay, thank you very much, Prof, for answering the questions. Now, my next question is to the legal guru. Now, here is the question. If the research team asks participants to write their names in the informed consent form, which is a legal document, the way the institution wants, versus what the participant wants or is in their national ID, would that be an issue?
I'll repeat again. Sorry.
If a research team asks participants to write their names on the informed consent form,
The way they want.
okay, the way they want, sorry, the way the institution wants, versus what the participant wants or is in their national ID, would that be an issue? Maybe let me give an example. My name is Mwaka Erisa Sawakachi. Okay, that's what is on my ID and national and passport, everything. But then I come to your research site and I want to use Sawakachi Erisa, leaving out the Mwaka name. Now, for you, you want me to write all my names, whereas for me as a participant, I want to write somewhere. Would that be an issue?
I think it's less of a legal question than because I think the research perspective of the Act defines personal data as data that can basically identify a person. So if you are known as something else to the general public, the use of that name, despite it not being part of your national ID, is actually part of your private information because people can identify you anyway. If I say Rasta, everyone knows you in the area as the Rasta of Ginger, so you'll still be known as that person. So for me, I think it wouldn't make a difference whether you collect the information.
Okay, thanks very much. And now this one is also for you. Do you have any idea of whether UNCST, UNRO, NDA, and the likes were consulted during the process of developing the DPPA law? Or, put differently, did they take interest in it, contributed to the process? What lessons are learned or are drawn for future actions?
I think we know where that question is headed, right? To the UNCST, UNRO, and NDA. Were they consulted? Did they take interest? It's not mine, really.
So he's a very tricky man. He's now pushing the question to UNRO. Good enough. We have UNRO and we have National Council. Were you consulted? Did you actively participate in the drafting of this law?
Dr. Okware, will you go first or I go first?
Okay, ED, you can go first. Martin, you can go first.
Okay. Yeah. Okay. Thanks a lot for raising a question. And I think the Data Protection Act, I would actually say that it occurred mostly like a cut and paste, because as you know, around 2018, there was that general global movement on how data is collected and used. And I think in the Ugandan case, because this involved, there was a lot of information circulating, and they looked at it basically from an IT perspective, data collection process, and they felt that it was not more to do with research and the like. So there was very limited consultation on that particular issue. As far as my records I have seen, there is nothing. But I think it's important that we should engage and look at a way of making sure that that policy doesn't have a hindrance to innovation. Because by true definition, with research, you are moving from what is known to unknown. And in the unknown territory, there are so many things that take place. Like, for instance, at the moment, we are relying on our screens, and that came out because of blue LED. But then the regulations and the data regarding like such new and transformative technologies sometimes are very limited. So I think in future, at the policy perspective, is how do we balance those regulations? And then we also have to look at it in terms of the innovations that we should be having in the pipeline. But also the other issues like I listened to Dr. Juko's presentation. I was wondering if a graduate student or an undergraduate student is listening to the presentation, the fellow may just get scared from science completely. So I think there's that balance that we need. Thank you. Over to you, Dr. Mwaka.
Okay, thanks very much, Dr. Okware.
Actually, my colleague has answered. She's very careful. I think I'll even be more careful when I'm answering this question. Just again to say that about 4 or 5 years ago, you remember there was that consultation on data mining. We were concerned that we put data in the internet and only a few people have access it. So there has been some discussion, but I was not sure that we did invite NIT at that time. I think they were there in our meeting. So we thought it was a general thing for public good for us. But you sort of surprised me that they have taken advantage. And because I remember that time, the data goes up, you're given a smartphone. There's a lot of these programs here, even here. We are doing HIMS, Health Information Management Systems, where data is given in real time. We don't know who is using that data. That's really the problem. But also at the same time, where we are today, do you really control anything? With the very moment you have a smartphone, everybody knows where you are. where you were yesterday, where you're drinking the other day, even all your particulars. But so I think for now, instead of fighting, let us look at the bigger good, public good. Can we take advantage of the data which is available before these people from the law council catch up with us? Because they also may not know as much to be able to take us to court effectively and win. So for now, for us, we are selfless as doctors and health persons. Let us just work for the good of the people. If there's a small epidemic, work on it. You people with your data, you sort it out later. Over.
Okay, thanks very much. Yeah, I can see people were very, very careful when answering that question. But I can summarize it that yes, there was some consultation, but maybe it was low key. Now, our last question, maybe the last two questions are for Helen. How and when do you withdraw drugs approved for compassionate use? How and when do you withdraw drugs approved for compassionate use? The hard one.
Maybe I'll also get for my seniors that I have to be careful how to answer it. Yeah. To withdraw drugs for compassionate use, of course, what we need is to follow those people who we have allowed to bring in the products, and there's usually an application for compassionate use, and that those drugs we are able to follow them up. Maybe what I would like to say is that the issue of say, like, if you find that you've been using it and it doesn't work well, and you have a lot of it, most of it in our situation, of course, has passed through the health system, the public health system, and it's easy to trace that back through NMS to be able to either destroy it if it has expired, or if it is still of use, maybe to repurpose it for another function. So usually, to get to that decision of withdrawal, you have to say that either it's expired or it's no longer needed for anything else.
Or when it's proven that actually it's not working.
It's not working, yeah.
Okay, now this one I just want to throw a small spanner in the works, and this one will go to my legal guru. Now, people signed a consent form before getting the jab. Now, if somebody gets a severe adverse event or a complication, okay, and goes to court and sues maybe the government that you gave me this thing, but I signed then you'll tell them, you signed a consent form. Then they'll tell you, no, I signed something I didn't know. Actually, they are just signing a form, but many of them do not know what they're signing. Would they have a case? This is a vaccine being used, I mean compassionate use.
I think they would have a case. Like Dr. Koi was saying, well, you have your time looking for data, but that's our job. The lawyer's job is to look for the information that's going to make them rich. At the end of the day, it's about money for lawyers. I don't know about researchers. So if the lawyer wants the information, they will find it. So, however, I looked at the judgment in Naigaga and I was like, this judge could have gone either way. The issue about informed consent, you withdrew, you signed it this way. The judge could have gone either way, depending on the reality, what we do on the ground. We know how we get informed consent for real. Someone signs and, that is problematic. And also, what do we write in the forms? If you told me, there are these terms you use in medicine that I will suffer, most likely I will suffer from something called something. What do I know about that? You offer me some money, I'll sign for it, go in your clinical trial, I get these complications, I will sue you. And it's a matter of balancing facts. I may win, and most likely I will win because I'm a small guy. You're a big guy, and the money is, you won't be hurt that much.
Okay, thanks very much. And this is the last question, and I think I'll answer this one. It's directed to Helen. Are the current COVID vaccines still experimental or already approved for treatment. There is only one vaccine that has been approved, and that's the Pfizer vaccine that has been approved in the US. All the others are still experimental. So thanks very much. Thanks very much for this lively plenary session. So I would like to invite Dr. Martin Ogol to wrap up, today's the proceedings of today's two plenary sessions. Thank you, Martin. The microphone is yours. Thanks very much.
Yes, sure. Thanks, Professor Mwaka, for chairing this session. And I would like to thank all the panelists and presenters for the wonderful presentations that were made today. I also looked at the number of participants. I saw like there were over 550, about 500 participants, and that's quite a significant pool of participants. And I've seen most of you have been very active on the chat. And actually, those bits of information that you have shared with us, the questions that you have presented, those shall be like a feed for the next co-creation process as we try to advance the governance, regulations, and the monitoring and evaluation of research management systems in Uganda. And then, of course, the presenters, of course, had very useful comments. I like the one from Professor Tumine about the advert, which is all over the city, that, we can provide proposal writing and all that processes. And recently in the BBC, they have identified Kenya as one of the the leading country actually in writing papers for those who are based in Europe and above. But the issue is that with science, it thrives on integrity, and once any aspect of the ecosystem is tampered with, then the validity of science then becomes a big problem. I remember in one article that I read, there was a survey to the community about whom do we trust, and in that country, actually, they trusted the witch doctor at a higher level compared to a scientist. So we need to really make sure that really what we are working on really is intact and it is sound. And of course, Dr. Helen from NDA also provided some guidelines on compassionate use and emergency use. And of course, during this pandemic, that's one area where as regulatory authorities, we are also facing a lot of issues in that area. And then, of course, there's the data protection issue with the new regulations being in place. I think that's something as regulatory authorities and the research community we need to watch. I can see quite a number of people logging off, so let me just try to say that tomorrow at 11 to 1, we shall be live on NBS TV, and the Honorable Minister of Agriculture, Animal Industry and Fisheries, Frank Tumwebaze, will be our chief guest. And during that moment, we shall be launching the guidelines on animal research in Uganda. So please make sure that you are there at that time. But otherwise, we shall be starting our sessions at our normal time, that is at 8:30 tomorrow in the morning. And of course, at 1, we shall be closing, and we shall depart at that time. Otherwise, I would just like to say thank you to everyone, and it was great having you today. Bye-bye, and I wish you the best. Thank you.
Yeah. Thank you. And maybe also a reminder, this is evaluation time. Please fill in that form. Fill in that evaluation form on your screen, please. Yeah, thank you very much. for the online participants before you leave. Thank you. So at this moment, I would like to thank my co-chair, Professor Mwaka, Dr. Ndajije, and Dr. Juko. Thank you very much. And thank you very much to all participants. Yeah. Have a great day, and we look forward to your participation tomorrow. Thank you.